Yes, be ready for the dictation. Start. Mobility of the officers of one cadre to another state cadre is only provided for by Rule 6 for some exceptional cases. Stop. But as a rule, members of one state cadre are not deputed to another state cadre. Stop. The makers of the Constitution, who used the words common to the unions and the states in Article 312, were aware of the pre-existing IAS and also its predecessor, the Indian Civil Service. Stop. In both of them, the commonness consisted in the fact that officers of a state cadres used to go on deputation to the central government. Stop. They may thus be presumed to have the same commonness in mind in using the above words while enacting Article 312. Stop. Further, Article 312 bracket 2 shows that Article 312 bracket 1 essentially continued the same system of commonness as obtained in the pre-existing IAS. Stop. This is why the Indian Administrative Service was deemed to have been created under Article 312 bracket 1. Stop. This accords with the established rule of construction of statutes that legislature does not intend to make substantial alteration in the law beyond what it explicitly declares either in express terms or by clear implication. Stop. It is true that the conditions of service of the officers of the Union Territories cadre would be same as those of the officers of the state cadres of the IAS. Stop. But the initial recruitment to the Union Territories cadre was under Rule 4 bracket 5 of the recruitment rules by a method different from the usual methods of recruitment to the Indian Administrative Service under Rule 4 bracket 1 of recruitment rules. Stop. Further appointments were made directly to the Union Territories cadre, while under recruitment and cadre rules, appointments are always made to the Indian Administrative Service first and officers of the service are later allocated to different state cadres. Stop. The mere similarity of conditions of service cannot make the Union Territories cadre common to the Union and the states when in fact such a cadre can never serve in any state at all. Stop. The next question, therefore, is whether the Union Territories are state for the purpose of Article 312 bracket 1. Stop. Article 312 is a part of Chapter 14 of the Constitution, which is significantly entitled Services under the Union and the States. Stop. Part 14 does not create an All India service. Stop. The reason seems to be that the consent of the states for the creation of All India services given in 1946 related only to the Indian Administrative Service and the Indian Police Service. Stop. Therefore, Article 312 bracket 1 states that more All India services could be created only after specific consent of the states for them is obtained by way of a resolution of the Council of States. Stop. The All India services referred to in Article 312 are thus obviously different from the services of the Union and those of the states dealt with in Article 309. Stop. The difference is that while services of the Union and the states are unitary services serving the governments of the Union and the states exclusively, an All India service, as its name shows, is a truly federal service common to both the Union and the states. Stop. The key to the meaning of the word state used in Part 14, including Article 309 and 312 bracket 1, is provided by the interpretation clause in Article 308. Stop. Before the Constitution 7th Amendment Act 1956, Article 308 was as follows. Stop. In this part, unless the context otherwise requires the expression state means a state specified in Part A or Part B of the first schedule. Stop. The definition thus made it clear that the word state in Part 14 was not to include Part C states. Stop. Union territories are the successors of the Part C states. Stop. It follows therefore that they are also expressly excluded from the definition of state in Part 14. Stop. There is nothing particular in the context of Article 313 which would require the word state therein to include a union territory. Stop. Stanza. The federal scheme in the Government of India Act 1935 and the Constitution is clear. Stop. The internal sovereignty is divided only between two units, viz. The Union and the states. Stop. The chief commissioners provinces followed by the Part C states, which in turn were followed by the Union territories, were not federal units. Stop. They did not share in the internal sovereignty as they did not have internally sovereign executives and legislatures. Stop. Just as prior to the Constitution 7th Amendment Act 1956, a Part C state was always distinguished from Part A and Part B state, which had internally sovereign executives and legislatures. Stop. Union territories have been distinguished from states throughout the Constitution, beginning with Article 1 bracket 3 thereof. Stop. Under Part 4 of the Government of India Act 1935 and Part 8, including Article 239 of the Constitution, the Chief Commissioners provinces were administered by the Governor General, and the Part C states and the Union territories were administered by the President. Stop. Reliance on this definition has led to a widespread confusion of thought and must therefore be clarified at once. Stop. Article 367 bracket 1 of the Constitution applies to the interpretation of the Constitution. The provision of the General Clauses Act as adapted under Article 372 bracket 2 of the Constitution. Stop. In view of Article 372 bracket 2 bracket A, such an adaptation had to be made within 3 years from the commencement of the Constitution. Stop. The definition of a state in Section 3 bracket 58 of the General Clauses Act as adapted by the adaptation of Laws Order 1950 issued under Article 372 bracket